Our next file this morning is People of the State of Michigan versus Tyler Innes. File number is 25-14163FH. Appearances, police.
Jake Carnes on behalf of the people.
Good morning, Your Honor. Ryan Ames, we have Mr. Innes, who's present and standing next to me.
I'm sorry, thank you. Mr. Innes is now here. You can go ahead and take a seat. Also here before this court this morning, Mr. Sean Van Atten. He's the agent from the Michigan Department of Corrections who has prepared today's pre-sentence investigation report. All right, Mr. Carnes, is there any victim impact statement to be presented today?
Yes, Your Honor. Ms. Strickland is going to read a statement on behalf of the victim.
And if you could, just make sure you don't, Ms. Frick, just don't use the individual's name.
Okay.
Thank you.
Dear Judge, I wasn't sure I wanted to write this letter. I want to forget it all, but somehow I can't. Tyler was supposed to be my brother-in-law. Tyler was supposed to be someone I could look up to like a brother. Instead, he caused me hurt I will hopefully someday overcome, but still have not. I struggle with relationships. I struggle with trust. I struggle with being able to be around the family house where it happened. What Tyler did also caused a severed relationship between me and my sister, me and my niece, so I have missed a lot there. I have to live with this daily, even when I want more than anything to just forget it all, I can't. That's why I wasn't sure I wanted to write this letter, because I don't relive it all, but with or without this letter, I still relive it all in ways it's hard to explain to people. So when asked what I think of his sentencing recommendations, why should Tyler only get a couple months? Why should he receive a slap on the wrist for something that I'm going to face every day for the rest of my life? Imagine watching every time you're around your sister, it being a constant reminder of the person who took your innocence. I hope I someday come to terms and be okay, but as of today, I am still not okay. Tyler should receive a real sentence, a true punishment. He never does when he gets in trouble with the law. So maybe this will do something for society and teach him that what he did was wrong. And if he finally gets the max you can give him, maybe that will help others also. And something.
That victim impact statement hits hard. Notice how the focus isn't just on what happened in the past. It's on the lasting consequences that continue every single day. In sentencing hearings, judges often weigh not only the crime itself, but also the long-term harm described by victims. And here's a question for you. Should emotional and family damage carry as much weight as physical evidence when deciding a sentence?
Good can come from this, and no one else will feel the hurt and trauma I have. Thank you for listening to my story and taking my feelings into consideration.
Thank you, Ms. Frick. In addition to that, I'll also note that I've read information presented here in the pre-sentence investigation report appearing on CFJ 284, pages 4, continuing on to page 5. Thank you. I'm going to turn to Mr. Carnes first. Your allocution, sir.
Thank you, Your Honor. The victim's words there did echo things both she and her aunt told me when we met when this case was first charged. In that this conduct really disrupted their whole family dynamic. I mean, this is, I guess I'm just going to leave it at that. It disrupted the family dynamic. I want to respect the victim's anonymity here. I think the recommendation for 60 months probation is reasonable. I'll ask the court to follow that. I do not think that the 120 days jail is sufficient. I would ask the court to sentence to 365 days jail with the 60 days probation. Thank you.
Thank you, Mr. Carnes. Mr. Niegos, any allocution, sir?
When on CFJ 284, in the evaluation plan, the second paragraph begins with on 325. There's statements made in there about my client's position and assessment of the case. And initially I was going to ask that that be struck, but you know, frankly, I think that that needs to be in there insofar as it does, you know, some of the statements in there, some of his understanding, because Tyler is a young man, is somewhat misunderstood and misguided. That being said, I will tell the court, without otherwise delving in attorney-client information, that around that time, I am looking at additional investigation that my office conducted into this matter due to the fact that that's how we got to ask for this adjournment. And I had prepared a motion to withdraw the plea based on some of this other information that came to mind. Following that investigation with our private investigator, I spoke with Tyler as well as his father and grandmother, who are present in the courtroom, along with the significant other, Ms. Grossman. And ultimately, the decision was made not to pursue a motion to withdraw the plea. Primarily because Tyler wanted to put this matter behind everyone involved. He didn't want to put the victim through a trial in this case. He did not wish to put his family through a trial in this case. And he sits before you as a 20-year-old single male who does have a checkered past. Now, that checkered past, thankfully for him, is not revealed through multiple hits on his proverbial history. He does have one serious prior felony, but he does acknowledge making a series of poor choices in his late teen years. He doesn't deny being part of that gang that again, Denise for the victim talks about in her statement in the report, and doesn't shy away from those really, really poor choices that he made. That being said, Judge, he is 20 years old. The court, and I know the court doesn't ignore this, he has already been placed on the sex offender registration, which, you know, in my opinion, does play a significant punitive effect on a young man's life going forward. Simply being on that sex offender registration does add, as the court always does and often says in its sentences, you know, the job of the court is to look at punishment, deterrence, and rehabilitation and mingle the three together. And I would ask the court to consider that at 20 years old, with, you know, being on the sex offender registration for the next 25 years is a significant punitive element in this. Furthermore, Judge, he has been on bond for a significant period of time. As a young man who does have a history of making poor choices, I would also, you know, pray that the court looks at the fact that he has been bond compliant, that there have been no, again, being a complicated case, one where there was at least the contemplation of withdrawal of the plea, there was no active communication from Tyler towards the victim, his prior significant other who's related to the victim, as well as any other people involved. And I can tell the court that he did exactly what I asked him to do, which is document when there were either direct or indirect attempts, because unfortunately the court knows these situations are very difficult for everyone involved, as we heard from the victim. And oftentimes that contact does linger while the case is pending. He didn't engage in any of that. He documented what he perceived to be potential attempts to get him involved, send him to my office, and otherwise stayed away. I'm very pleased to tell the court that his father I've had good conversations with him, is present here in the courtroom, and I think he's a really, really important figure in Tyler's life as he attempts to turn his life around going forward. Ms. Grossman is present. They just revealed in a very, I don't know what the right word is, that she just told me this morning, and his father just found out this morning that they're expecting a child. And I believe I sent to the court over the weekend and late last week a number of significant character letters on his behalf. Now, I acknowledge that those come from friends and family, but again, he's a 20-year-old young man who is just now in the early onset of shaping his life and hopefully doing a 180. I also sent this morning
The defense is making a classic sentencing argument here: youth, family support, employment, compliance with bond conditions, and now even news of a child on the way. They're painting a picture of someone who still has a chance to turn things around. But here's the dilemma. How much should future potential matter when the court is sentencing someone for past actions?
a letter, I don't know if that may have made it into the file or not yet, from his employer,
There
who's
was
aware
one-
of what's going on,
Yeah, there
and
was one
stands
that,
by Tyler. Thank you,
there's one
Judge.
that we received just this morning.
Thank you,
So,
Judge.
Yeah, I got it.
So ultimately, Judge, this is a scenario where, again, the court always says and advises that the defendants that the guidelines are discretionary. And look, Tyler is here. He's here ready to accept the sentence for what happened in this case, for the choices he and only he made. Again, I do want to emphasize the fact that he is a young man who did not take advantage of some of the mentorship and otherwise the right guidance he has had in the form of his family. And again, his father, someone that, again, not vouching for Tyler, but vouching for his father, is someone that I think is a significant positive influence on Tyler, as in an effort to not have this situation define the rest of his life. We acknowledge the victim's comments. We certainly do not have any interest in minimizing any of that, and Tyler respects the consequences of his actions and is again, he pled no contest. It's a complicated situation. He's unable to, frankly, on my advice, express some of the things that he feels, but I can just tell the court as an officer of the court in my discussions with him that he's taken this exceptionally seriously. I would ask the court to consider 60 months probation for a 20-year-old young man, again, that is meant to rehabilitate, to significantly deter, but in some ways, it's also a punitive element insofar as probation is expensive. There's cost associated with it. And ultimately, we would beg for the court's grace in finding a sentence that ultimately, again, mingles the three goals. If the court gives him jail time, and finds that that is necessary in light of this conduct, he will certainly serve that. I would ask for the court to consider Mr. Karn's request and put all of this squarely on Tyler's 20-year-old shoulders that must begin today be significantly broader. Hang 365 days, Judge. Hang that squarely on him. Give him an opportunity to see if the last 10 minutes I spent blabbering on his part has just been a bunch of BS that he sold me. And then he screws it up. He does the full year, or worse. Obviously, you could send him to prison on these guidelines. But I would ask that the court give him an opportunity to continue to look at the 6, 7, 8 months he's not on bond, his employment, the relationship he's now repaired with his family and his dad being right there on him each and every day, and give him an opportunity to remain free at this time. My last comment, so if he doesn't feel like I forgot something from him, he also wanted me to know that, Judge, that he works night shift. His partner now works day shifts. He does have more access to his current minor child and does provide some care to that minor child. Thus, again, an incarceration period would be further damaging to that dynamic. But again, as I told him outside, ultimately it's up to the court, and he needs to take responsibility and accept whatever the court gives him today, and that's what he's going to do. Thank you, Judge.
Mr. Ennis, you do have the right to make a statement, as Mr. Diegos highlighted a bit when he talked about this being a no contest plea. I do the same thing. I let you know that obviously in a no contest plea, I don't expect to hear from a defendant. I just need to make sure that because it's your right. If you choose to make a statement, you can, but anything you say can be used against you. All right, is there anything you wish to say, or do you really wish to rest on what Mr. Diegos had to say? All right, thank you.
And now we arrive at the moment everyone in the courtroom has been waiting for: the judge's analysis. This is where sentencing hearings become fascinating, because judges aren't just calculating numbers. They're weighing accountability, rehabilitation, public safety, and the law itself. Watch closely, because the judge's reasoning can sometimes be more revealing than the sentence itself.
Thank you, Your Honor.
All right. Well, I might go in a place maybe not everybody's focused upon. If there is a letter in here, and there are a couple, if you tell me that he's innocent, I crossed your letter out. No, he's not. You disagreed and blamed it on the other family. I don't care. I'm sorry. I can't. He entered a no contest plea. When he enters a no contest plea, the word contest means he doesn't challenge what is in the report, and what is in the report is considered fact. So if you spent your time telling me he's innocent, pointing fingers across at other people, Your statement just has a big X across it. Sorry, but you don't get to come back here and contest it. Now, I don't know how to handle this, but I can tell you the question I want to ask. Because he entered a no contest plea and he's elected to not make a statement. I'm not going to. But I want to know where he started smoking weed. Where were the parents at this address? Whoever has helped demonstrate that this young man is smoking marijuana is a good choice. You, if there is anybody, if you just picked it up on your own, okay. But if there's anybody in your life who's allowing you to smoke marijuana and telling you it's okay, they are in part the reason you are sitting right there. They are just as guilty to some degree as you are. I hope it's not a parent. If it is, that's called bad parenting. You're 20 years old. It's illegal for you to do so. And then in here, according to the information, you were then giving it to a 15-year-old girl. It went down the line. So if anybody in your family is helping let you smoke weed or buy marijuana or let you think it's okay, they're wrong. Now that goes for the same people who run this house. I know this house. I grew up right across the street. The little house in the corner of Crippen and Shelby, the green one, the dump. That's sorry, I don't mean to be dumb, rude, but I live there. I grew up there. I know this house. I used to go to birthday parties in this house when I was a kid. Now it's been a long time, so I've been in it 50 years, 40 years. But I look at this and I want to say, well, where was the parenting here? You got a 15-year-old girl. Where were the parents? See, when people come to court for sentences, they tend to look at everything from their own perspective. And they don't look and see, well, what did I do wrong? Because this is a complete failure. If you're bringing weed and smoking it in this house and those people know it and they're letting you do it, shame on them. They're letting you hang around and be around their 15-year-old dog, shame on them. If somebody else is out there helping you get marijuana, shame on them. They've set you up for complete failure. And I'm sorry that you did it. But you did. When you fill your brain with another substance, you are going to do stupid stuff. And it's been that way since mankind's ever existed. And we'll never learn our lesson. And we'll just keep doing it. So, really unfortunate that you're a pothead at such a young age. And you've got this ABM all about the money game. And I don't know. This is a failure of a lot of people. I don't think it's one where you targeted and went there. Give her weed, so you were targeting her, but apparently she knew how to smoke it. Good God. So, all right, but you also got a heck of a deal. And I mentioned this earlier. There could have been other scoring here. A caution to child for immoral purposes, delivering marijuana to another person. So these guidelines, which aren't complete, definitely are inadequate, but they're that way based upon the plea. And I'm not going to criticize the plea. If the victim and her family wishes to criticize the plea, they need to go to the prosecutor. They don't need to come to the judge. And I'm stuck by following the law.
This is an important legal point. The judge is explaining that sentencing isn't always about what he personally wants to do. It's about what the law allows him to do. Many viewers assume judges have unlimited discretion, but that's rarely the case. Plea agreements, sentencing guidelines, and statutory limits can significantly narrow the available options.
It's a good thing, it's what judges are supposed to do. You have an intermediate sanction cell. That means that when the victim and the family, if they supported it, knew that it was going to be an intermediate sanction cell. And the law says that I'm to begin with the presumption of jail, fines, costs, and probation, except it's a CSC, I got it, and there can be some exceptions. But again, I'm looking at this and I'm like, listen, I don't know what everybody's expecting here. Anybody else, if any member of these two families are doing weed, marijuana, and allowing you and encourage, stop it. Now, the law actually allows me, but I'm not going to because it's a no contest, but I can put you under oath and ask you questions about it under pursuant to MCL 771.1 parenthetical 4. I'm not going to because I want to know where you get it from. I'm not going to today. All right, so with this out there, you know, you picked up this assault battery. Well, I know that that case occurred after this one, but before this one, there was an arrest. You had to know that there was an investigation going on. So I don't know what to tell you. There's so much here going on that's wrong, but it's reduced down to a CSC2 with a maximum punishment of up to 4 years. So done enough talk. And I did read all these statements. Obviously, I'll tell you what, there was one that bothered me. I'm just going to read the one line. There were several that said they blamed how you were innocent. That one I ignored because that comes from moms. Please take into please take into consideration the amount of inconvenience this family has brought into my brother's life. What inconvenience did this other family bring into your life? I don't know. She's 15. You were 20. Don't write letters and tell me it's a battle between the families. The sentence of the court is as follows.
Here comes the verdict on punishment. Notice the tension in the courtroom. The victim wanted a harsher outcome. The defense pushed for probation-focused rehabilitation, and the prosecutor sought additional jail time. The sentence is about to reveal where the judge believes the balance should be struck. Do you think justice is best served through punishment, rehabilitation, or a combination of both?
I'm sorry, yeah. I'm sorry, did somebody say my name? No? Oh, sorry, thank you. All right, here we go. The court places the defendant on a period of probation for 60 months. It's the longest I can put you on probation by law. However, you have the right to be considered for early release from probation if you are compliant with all your terms and conditions at halftime. So in other words, after 30 months. Now, the court adopts the terms and conditions that are listed in the pre-sentence investigation report under CFJ 145 pages 2 and 3. I find that they're well suited for rehabilitative purposes. But I'm going to highlight specifically the fines and costs. There is a $68 state minimum fee, $130 crime victims' rights fund fee, a $300 court cost, a $300 fine, a $300 attorney fee. There had to be a DNA taken.
Yes, Your Honor, my notes say to the Cadillac Police Department.
All right, $60 DNA fee to the Cadillac Police Department. There probably should have been a $90 HIV fee because of the charge.
Read my mind.
Thank you. So there's a $90 HIV fee. Supervision fees are $30 a month. $60 a month if there's any electronic monitoring, but you've been compliant, so I'm not going to push electronic monitoring. Right. There wasn't any request for restitution, and so that leaves a period of confinement. The recommendation is 120 days. Now, this is where a judge gets put into an awkward position because somebody's going to look at this and say, oh my gosh, Judge Elmore didn't put him in prison for 2 years. Well, I can't, by law. Well, he didn't put him in prison for X, Y, and whatever time. I can't. The prosecutors are the one who cut the deal, and I'm not challenging them. They did so based upon their knowledge of the file. I'm not criticizing the prosecutor, but I am limited by the law. Now, this court sentences the defendant to it's still within the guidelines.
A 180-day jail sentence, more than the original recommendation, but still within the legal framework the judge repeatedly emphasized. What's striking is that the judge spends almost as much time explaining why he reached this decision as he does announcing it. That's often a sign that the court expects the outcome to be controversial. Let us know in the comments. Was this sentence fair, too harsh, or not harsh enough?
And it's going to be a 180-day jail sentence with, I think it was 2 days of credit. That is to begin immediately. All fines and costs are due within 56 days from today's date. Only 20% penalty will be added. However, the court will waive that penalty as long as the defendant is making payments throughout the period of his probation. And of course, he's already registered as a sex offender under Tier 2. Anything else that I've missed, Mr. Benatmo?
Just to be safe, I think the order has to say you must comply with the sex offender.
Or you must comply with Sex Offender Registration Act. I'm sorry, I thought he, yes, thank you.
Yes, Your Honor.
Yep. All right, so anything else, Mr. Ernst?
No, Your Honor, thank you.
Mr. Ennis? Stop living in the world of marijuana. It just puts you in the jail and on the sex offender registry. I do hope you good luck. You're very young. You're going to learn from this. You're going to put it behind you. I know you will. I've got to concentrate and look at photos to remember being 20 years of age. So I really do hope that you learn from this. When I pick my words and even my tone, I'm trying to figure the right way to do it. I don't know if I do it right. Sometimes I feel horrible because I really care about you and I care about the young girl in this case. I care about everybody that comes in front of me. I don't know if I did it right today, but I hope I did, because I hope when you get out, you change your path. Good luck. We're